that it be decided whether the police are or are not entitled to enforce the provisions of the Act. Secondly, we respectfully submit that the prospects of success are good and that under those circumstances, condemnation ought to be granted. I submit also that the non-compliance is of a limited nature, and as members of the court will have seen, there were repeated attempts by the State Attorney to rectify the errors that had been made. Those are my submissions.
No worries. And if we should be inclined to grant condonation, what would we do about costs?
Justice Mauer, we would have to pay the costs of the application for condonation.
Any questions, colleagues? None. Okay. Mr. Van Rijn?
As the court pleases, I've only got one submission in respect of the delay, and that is that on the 13th of February 2019, the respondent's attorney of record alerted the State Attorney of the fact that there was no record at the registrar of this court of a notice of appeal having been delivered. No notice of appeal was delivered as a result thereof. The respondent's attorney alerted the State Attorney again on the 11th of April that a notice of appeal had not been delivered. Only then an application for condonation was brought and a notice of appeal was delivered. The State Attorney denied under oath that he has received the notification of the 13th of February. In the duplicating affidavit delivered on behalf of the respondent, it is pointed out clearly that the State Attorney had in fact received that notification, and he replied thereto. And then in an application for condonation, he denies that he received it. The court will find the references to the documents I refer to on page 32 of my heads of argument. Maybe I can just take the court to page 686 in volume 4. Sorry, in the supplementary volume. There, the respondent's attorney of record sets out what transpired, and if one has regard to page 689, there is the email to the State Attorney sent on the 13th of February at 14 minutes past 3, it appears. Please find letter for your urgent attention. Then if one turns the page, at the bottom of page 690, the State Attorney says, "Morning, Larry. The registrar accepted service by way of email as your offices were closed, but I will check with my correspondent attorneys and revert." And then there's a further email from Mr. Marks advising that his correspondent also inquired and that the registrar had no record. Therefore, the submission is that at least from the 13th of February, the State Attorney knew that there was no notice of appeal delivered, and he did nothing. We say it is not in the interest of justice for the appeal to proceed because, firstly, the order is not appealable for the reasons set out in my heads of argument, and secondly, there are not good prospects of success on the appeal. Those are my submissions.
Done this from home. I think the connection is better than.
I think this one is fine.
Might I inquire whether my submissions were heard?
Mr. Van Rooyen, is Judge Zondi, I did hear your submissions.
Judge Kippers, I heard your submissions.
Thank you, Judge Zondi. Thank you, Judge Skip.
I'm sorry, Mr. Van Rooyen. You know, I made a big mistake. I'm actually sitting at the court, and I was promised that the room in which I am has the best connectivity, but it does not appear. So I was cut off when you were still. That was about 3 minutes ago. Can you just retrace your steps to when you were referring to an email where Can you just retrace your steps a little bit?
I will do so, Justice Maya. If I may refer you to the supplementary volume, page 686.
All right, I heard you up to that point.
All right, Justice Maya, then I referred to the string of emails starting from page 689 at the top and further. If one goes through those emails, it will become clear that on the 13th of February 2019, the respondent's attorney of record advised the state attorney that there was no record of the appeal at the registrar. The state attorney, in his replying affidavit, denies having received that email of the 13th of February. However, if one looks at the emails from page 689 to page 691, it becomes clear that the state attorney had in fact received that email and that he had in fact replied to that email. So the submission is from the 13th of February, the state attorney was in willful default. He knew that there was no notice of appeal. My submissions were that firstly, the state attorney the appellants were in willful default, and secondly, it is not in the interest of justice to grant condonation because, firstly, the order is not appealable in any event for the reasons set out and advanced in my heads of argument. I'm not going to repeat them now. And secondly, because prospects of success I submit in the appeal are poor. Those are my submissions, Justice Meyer.
All right. Thank you so much, Mr. Van Rooyen. I came in at a stage where Judge Zondi was asking a question. I don't know if he wants to put it again just for my benefit, or if anyone had posed questions before him.
Justice Meyer, it was in response to the question by Van Rooyen if we had had his submissions in the light of the fact that there was some interruption. And my response to him was that I had his submission. Are you with me, Judge Meyer? Hello, Judge Meyer?
I got caught.
Yeah.
Can you see and hear me now?
Okay, I can see you. Okay,
I just got cut off for a second. No,
you are just frozen now. Can you hear me now, Josh Meyer? Josh Meyer? Can you hear me now?
Oh, I am so sorry about this. You know, the irony is that the only person who's at the SCA is the one who's having problems. Apparently, I'm in the reading room and the technician thought the connectivity is best there, and that's not the case. So I'm just going to move location. Can you just give me 5 minutes to move my records and I'll be back with you, please?
Okay, thank you.
All right, thank you. Let me move here. All right, I'm back on. I'm holding thumbs that things will work well from here on. All right, I was still asking you a question, Mr. Van Rijn, that having regards to the importance of the matter and the fact that the commissioner would pay the cost of the application, what prejudice does your client stand to suffer if we grant condonation and just deal with the appeal?
There will be no prejudice for the respondent if the appeal proceeds directly as a result. No prejudice directly as a result of the delay, Justice Maya.
All right. If there is no prejudice, then why are we having this debate? No likely prejudice to be suffered. Were you able to catch what I said?
No, Justice Maya, I didn't. I heard you speaking, but I didn't hear a question. I couldn't hear what you said.
Oh, okay. No, I was just asking if your client don't suffer any prejudice if we grant condonation, why are we having this debate at all?
Justice Maya, because it could cut the proceedings short, because we say that the order it's not in the interest of justice, because the order is not appealable in any event, and the prospects of success are poor. So therefore we say that we could cut the process short if condonation is not granted. But there are no further prejudice.
May I just ask you, Mr. Van Ryn, in view of your concession, in the event that we should hold against you, is there any reason why the applicant should pay the costs of the application for condonation on an opposed basis?
Justice Ekstein, they are asking for an indulgence, but if you find against them and order them to pay the costs on an unopposed basis, it would be acceptable.
All right. Any further questions, colleagues? Mr. Batlender. All right. Any reply, Mr. Batlender?
Justice Meyer, just very briefly, that if there's a dispute as to whether the state attorney received the letter in question from Mr. Marks, and it seems to me my learned friend has the sequence of events of emails wrong, in fact. But be that as it may, we say that if the state attorney's account of the events is not correct, that shouldn't be visited on the appellants, who shouldn't be non-suited on that account. At worst, the notice of appeal was filed some weeks late, I think it's 6 or 8 weeks late, after a previous and timeous attempt had been made to file it. It's not a case where the appellant was supine, and we submit that the interests of justice require that the appeal be heard and decided on its merits. And in response to Justice Ekstein's question, my learned friend's concession, we respectfully submit that that's correct. But the costs ought to be ordered on an unopposed basis, if the court is with us.
Okay.
Thank you, Justice Meyer.
Thank you very much, Mr. Batlender. My colleagues and I will need a few minutes to confer and get back to you. Now, I'm just trying to figure out what the best way of doing that would be. There is a whole lot of people who are tuned in, who I would not want to... If we want to do that on this platform, then it means I must disinvite everybody, then we start over again. Perhaps the judges should just get off and we'll do a quick telephone link. May I, or do you, colleagues, are you on WhatsApp? And do you have your phones with you? Because we can just do a very quick WhatsApp conference.
Yes, Justice Meyer, I do have my phone with me.
Yeah, I'm also on WhatsApp. I'm on WhatsApp,
Yeah.
It's no problem.
All right,
I would have to get my phone.
Your phone is not with you?
No, but it's close enough.
Oh, all right. No, that is fine. Shall we take to give Judge Blasket a chance to retrieve his phone, just take a 10-minute adjournment. What time is it now? 10:16. Let's get back at 10:30. Is that fine?
Okay, sure, thanks.
All right. Thank you. We'll see you in a bit.
All right.
Jeff, is it only you and I?
I'm still I'm still here, Gerard. But my camera's off. Do you think are we supposed to hang up at this point and be invited back, or do we stay around?
That's what I wanted to ask you. I think we should. I think we should get out and, in that email they said that we could use the same link to come back after every break. So yeah. I think that's the intention, that we should leave. I see Justice Plaskett is also still here, but he's muted.
Yeah, I think it's inappropriate for us to...
I think we should just leave and come back. What did she say at 10:30?
10:30. I think just in case everybody should get off. Yeah.
Yeah.
Okay, thanks. See you shortly.
All right, we are just waiting for justices, or just Justice Skippers and Ms. Stefan Rain. I don't see them on my list of participants. Okay, let's just give it a minute. Oh, there's Ms. Stefan Rain. Just Justice Skippers now. All right. Welcome back, Mr. Van Rain and Mr. Chaskalsen. We are just waiting for Justice Skippers to rejoin us. Where is he? Okay, let me just quickly call him and find out what issue, if there is any, he's struggling with. Okay. I'm just going to give him a quick call. All right, we are all here. Oh, two more tiny issues to get out of the way before we get to the, my goodness. There's still an order to give in the condonation application. You know, I must say that it's highly unusual for a condonation application to be opposed, but there is absolutely nothing preventing any litigant from doing exactly what Mr. Van Rijn just did for his client. Having heard your submissions, we are inclined to grant condonation, and we would make a cost order on an unopposed basis and furnish our reasons in the main judgment. Colleagues, do you agree with the order?
I agree, Judge Meyer.
I agree.
I agree.
I agree.
Thank you. Thank you. All right. Now to serious business, but before we get there, there is a document in the record, Mr. Van Rijn, just for clarity, that purports to be a conditional notice of cross appeal, which you have indicated in your heads of argument that it's not being pursued. And I dare say rightly so, because no leave was granted for a cross appeal. Am I right? Should we just disregard that document?
Indeed, Justice Meyer, that document should not have found its way into the record. We are not persisting with the cross appeal.
All right. Then the other issue for me is that in your heads of argument, you keep referring to a volume 5. You've done so in a number of footnotes, and I don't have a volume 5. Could that be a mistake?
Justice Meyer, a supplementary volume was prepared by agreement between the parties. It was delivered approximately, I think, 3 weeks ago by the appellant, and there are important documents in that volume. At the time when the heads of argument were, I beg your pardon, Justice Meyer.
I was saying we did receive that supplementary volume, but it came as a supplementary volume, not a volume 5. So I Are you saying, therefore, that the references to volume 5 are actually references to the supplementary volume?
Indeed, Justice Meyer, at the time when the heads of argument were prepared, we all accepted that the volume will be called volume 5 and not a supplementary volume. But volume 5 and the supplementary volume is the same volume.
All right. My challenge was just that the pagination does not add up. The references in your heads to certain pages do not tally with the pages in that volume. So when you do refer as well, I will tell you as we go along when I have difficulties, and perhaps you can assist me.
May I inquire, Justice Meyer? My instructing attorney directed a letter at the registrar with a list of the couple of footnotes that make reference to those documents in volume 5 with their page numbers. Did you not receive that letter?
I do not have that letter. I don't know about my colleagues.
There are about 10 footnotes that do not have page numbers because the volume supplementary volume was not ready. If it's an opportune moment, I can take you briefly through my age of argument and give the relevant page numbers so that you can write them in, Justice Meyer, but there should be such a letter. It was directed at the registrar and it should have been distributed to the honorable judges.
All right, maybe let's just do that so long and get it out of the way.
Right. On page 1, there is footnote 1. The page number there should be 633. On page 3, you will find footnote 3, and the page number there should also be 633. Footnote 4 on the same page, the page number should be 647.
Right.
On page 13, footnote 10, page number should be 648.
All right.
The next one is footnote 33 on page 29, and the page number should be 633 to 634. The next one is footnote 35 on the same page, and the page number should be 633. The next one is footnote 41 on page 32, and the page numbers there are 564 to 566. The next one is footnote 42 on page 32, and the page numbers there are 686 to 687. And the last one is footnote 43 on page 33 of my heads. The page numbers should be 709 to 711.
711. All right. Got it. Thank you very much, Mr. Mbayi.
I offer my apology, Justice Meyer. This problem was foreseen and we attempted to sort it out, but it seems that the letter didn't reach the judges.
Yes, no, that's fine. No harm done. All right, Mr. Butlender, are you ready to finally address us on the merits of the appeal?
May it please the court, I am ready.
Thank you. Please proceed.
Members of the court, Section 28(1) of the Firearms Control Act provides that a firearm license terminates, that's the word that's used, terminates upon the expiry of the relevant period, which is set out in Section 27 of the Act, unless the license is renewed in terms of Section 24. Section 3(1) of the Act provides that no person may possess a firearm unless he or she possesses a license or permit or authorization for that firearm. And Section 120, subsection 1 of the Act provides that it is an offence to contravene or fail to comply with the provision of the Act. In the South African Hunters case, the Constitutional Court held at paragraph 19, I quote, "The gun owner knows that he must either apply in time for renewal or dispose of the firearm before expiry. If he does not do so, he will be guilty of an offence." Close quote. The South African Police Service, the respondents, the appellants in this case, are under a duty to enforce the law. In the main application in this case, the respondent, GOSA, does not challenge the validity of any provision of the Act. No validity is an issue in this case. Yet on the 3rd of August 2018, His Lordship Mr. Justice Prinsloo granted an interim interdict pending the main review, the main challenge, which prohibited the South African Police Service from the following. Firstly, from implementing any plans of action. I'm not sure what plans of action they are, but presumably they're plans of action relating to firearms with expired licenses. Secondly, they were prohibited from accepting any firearm with an expired license for the sole reason that the license is expired. Thirdly, they were prohibited from demanding that a firearm with an expired license be handed over to them for the sole reason that the license is expired. In other words, His Lordship Mr. Justice Prinsloo interdicted the South African Police Service from enforcing Section 3, subsection 1 of the Firearms Control Act. That's the effect of his order. If any person arrives at a police station, and this has been the situation since August 2018, and says, "I want to surrender my firearm because the license is expired," the South African Police Service may not accept it. They must refuse to accept it. If the South African Police Service find a person has a firearm with an expired license, they may not demand that he or she surrenders for that reason. Paradoxically, they may arrest and lock the person up because an offence has been committed. But if the possessor says, "Well, I would like to surrender my firearm because the license is expired," they must say, "No, we can't accept it." And they may not demand that the offender surrender it. In these submissions, in our oral submissions, I'm going to make, in essence, 5 submissions. The first submission we will make is that the order of His Lordship Mr. Justice Prinsloo is the clearest breach of the constitutional separation of powers. It's the clearest breach, and it should be set aside. The order interim interdicts, I beg your pardon, that it's the clearest breach. The interim interdict is therefore appealable, and the interim interdict should be set aside on the grounds that it's a clear breach of the constitutional separation of powers. The second submission is that the interim interdict is also appealable because of its immediate and substantial effects and the harm that will flow from it. The immediate and substantial effects and the harm that will flow from it. The third submission is that in any event, the interim interdict should be set aside because the final relief which GOSA is seeking has no reasonable prospect of success. And under those circumstances, an interim interdict should not have been granted. The fourth submission is that in any event, there is no admissible evidence which could justify the order which the High Court made. And finally, fifthly, I will address the question of costs. So if I can come then directly to the question of the separation of powers, that is dealt with in our heads of argument from pages 19 to 23. I'm not going to take the court through that, because by now the core principles applying to interim interdicts in relation to the separation of powers have been clearly established by the Constitutional Court. In the OTA case, dealing with the Johannesburg toll roads, court will remember that that SANRAL was prohibited from collecting toll fees and implementing the toll system.
Budlander, I'm sorry, Mr. Budlander, before you go there, could I just ask you one thing, please? And that is the GOSA's standing. As I read the founding affidavit, it brings this application in its own name. It doesn't purport to bring it on behalf of anyone, and it doesn't purport to bring it on behalf of its own its members. Yet it doesn't own a firearm, doesn't have a license to a firearm. Where does its standing come from?
Justice Plaskett, if there is standing, and I'm not sure that there is, it would come from its own aims and objectives. One would have to find it there. If it's furthering its own aims and objectives, then it would have standing to go to court to achieve them. If one looks at the aims and objectives, it's difficult to find one, I have to say, that fits what is now being brought before the court. The closest, I suppose, is the last one, which is to be the voice for the rights of firearm owners in South Africa. And I suppose if one were generous, one could say, well, that's what it's seeking to achieve. Though whether it really speaks for firearm owners in South Africa is not demonstrated. So that's the best basis on which there is standing for GOSA and Justice Plaskett.
Thank you.
If I then come to the OTA case, in that case, His Lordship Mr. Justice Prinsloo had ordered an interim interdict which, quote, in the words of the Constitutional Court, prohibited SANRAL from exercising statutory powers flowing from legislation whose constitutional validity is not challenged. Now that's what we're facing here. It's a prohibition on the police from exercising statutory powers flowing from legislation whose constitutional validity is not challenged. And the Constitutional Court held that the grant of the interdict had a, quote, a direct and immediate impact on the separation of powers. That's at paragraph 27. And the court set aside the interim interdict on appeal. The second case, which established this, the principle clearly, was the Tshwane City case. In the Tshwane City case, His Lordship Mr. Justice Prinsloo again had issued an interim interdict which prevented the municipality from changing street names pending a review. And the Constitutional Court held, quote, this is at paragraph 39, the effect of the restraining and mandatory order granted is to mortify and prevent the council from implementing its resolution. And this is the resolution taken in terms of its constitutional and statutory powers. To say that this amounts to an intrusion by courts into the domain reserved exclusively for the executive would not be an overstatement. So again, it was a case of an interim interdict which prevented the exercise of statutory powers. And again, the Constitutional Court set aside the interim interdict which had been ordered by His Lordship Mr. Justice Prinsloo. Of course, so the OTA case established that a court may order a temporary restraint, quote, against the exercise of statutory power well ahead of the final adjudication of a claimant's case, only in the clearest of cases and after a careful consideration of separation of powers harm, close quote. That, of course, assumes that there is going to be a challenge to the statute in due course, which there isn't in this case. And we submit that the High Court showed no apparent appreciation of the fact that its order would impinge on the separation of powers and the need to consider the separation of powers and what the impact was. This is what the court said in that regard. It's the court's sole reference to the issue of separation of powers. It's at volume 4, page 500. And it's from line 16. Volume 4, page 500, from line 16. The court commences, the arguments of Mr. Budland are with respect important and something not to be taken lightly. When a judge says that in his judgment, you know you're in trouble. You're about to get a clap. And he goes on and he says, for example, his argument already referred to the separation of powers. His argument that this doctrine of separation of powers does not permit a court to make an order prohibiting the executive from carrying out its constitutional and statutory obligations. Firstly, inasmuch as this only relates to relief against the police and the manner of executing the mandate in a more recognized and practical way, does not, in my view, amount to a situation where, for example, an executive policy decision is interfered with. This is particularly so given the Minister's news that an amnesty is imminent. The interim relief sought is only that, namely interim relief, and is encapsulated in one prayer, which is prayer 2, which featured in the pre-amended notice of motion, and then he quotes the order. That's his full consideration of separation of powers. There's no other place I've been able to find in the judgment in which the court considers the consequences of the order from a separation of powers perspective. And the statement that this order is not about interference with an executive policy decision, with respect, misses the point entirely. Yes, there's a separation of issues question in some cases about executive policy. Here's separation of powers about enforcement of a statute. It's the very matter which was identified by the Constitutional Court in the Ota case and in the Swane case. It is an interdict preventing the exercise of statutory power, and the court gave no consideration to that consequence of its order. In Ota, the Constitutional Court also held as follows. The passage is quoted in our heads of argument at paragraph 53. Quote, paragraph 53, page 22 of our heads of argument, second paragraph. Quote, a court must carefully consider whether the grant of the temporary restraining order pending review will cut across or prevent the proper exercise of a power or duty that the law has vested in the authority to be interdicted. That, with respect, was simply ignored by His Lordship, Mr. Justice Princely. He didn't consider it because he thought that the issue did not arise. The result of that order is that since 3 August 2018, the central feature of enforcement of the statutory system of gun control in South Africa has been disabled. People may retain, hold on to firearms in respect of which the license has expired in breach of the Act. The court had no apparent regard to this inevitable consequence of the matter, of her order, and it wasn't just an inevitable consequence, it was the intended consequence of the order. The intended consequence of the order was to permit a breach of the statute to continue and to prevent the police from enforcing the statute. The court interdicted the exercise of a statutory power where there's no pending challenge to the constitutional validity of the power, and indeed in circumstances where the Constitutional Court had just a few months earlier said that the provisions of the statute were constitutionally valid. And we submit that on this ground alone, the order is appealable and that it must be set aside. And we submit that that is the effect of the judgments of the Constitutional Court in matters such as Ota and Swane. And that with respect, I'm sorry.
Mr. Budlender, can I just ask you this, because I'm intrigued by this case. There is a judgment by Justice Nugent in this court in 2009 in one of the Zuma cases, where he made it clear that the court itself, or the judiciary rather, is bound by the principle of legality, and that it may issue no order that is that for which those of us who grew up in the old era, there is no vires. So where does the court get the power to do what it did here to effectively prevent the implementation of a law, in this case the Firearms Control Act?
Justice Skippers, there is no such power. There is no such source of power for a court to prevent the implementation of the law. There may be some circumstances, although it's difficult to imagine them, in which the statute, the consequences of the statute is plainly invalid, and there's a need for some interim intervention. I think that's a matter which can be debated at some length. But ordinarily, the court has no power to order that which is illegal, to order that which is illegal may continue. That seems to me that is the principle of legality, which is foundational to our constitution.
Mr. Butler, we seem to have lost Justice Plaskett. Please just press pause for a minute while I try and see what's going on.
Thank you.
We have indeed lost Justice Plaskett, but he's trying to rejoin and hopefully he'll be able to. So let's just wait for him, please. And we are losing Mr. Chaskerson as well, I see.
Justice Meyer, I'm back. I'm not
You
sure.
are? Oh, great. Okay, my list of participants told me otherwise. Yeah, I see you now. You are indeed back. Thank you. There he is. Okay. Justice Plaskett, I see you're back on board. Thank you, Lord. Okay. Carry on, Mr. Butler, please.
Thank you, Judge. Then that brings me to the second submission which we wish to make, which is that regardless of the separation of powers issue, the interdict is also appealable because of its consequences. In the Ota case, Deputy Chief Justice Moseneke held at paragraph 25 that an interim order is appealable if it has, quote, immediate and substantial effect, close quote, comma, including that, quote, the harm that flows from it is serious, immediate, ongoing, and irreparable. And we make this, close quote, we make the submission that each one of those descriptors applies to the order in this case. To disable the enforcement of firearm control inevitably results in harm that is serious, that is immediate, that is ongoing, and that is irreparable. And that is because there is an overwhelming likelihood of injuries and death being caused by the use of unlicensed firearms by owners who are no longer in possession of them, or for that matter, by people who've stolen them. And those injuries and deaths can't be reversed, and they are caused unlawfully because they're caused by the use of an unregistered firearm. Those are inevitable consequences of disabling the system of firearm control. And so we make the submission that on this ground too, the interdict is appealable in terms of the finding of the Constitutional Court at paragraph 25 in the Ota case. Then my third submission relates to, is the proposition that the final relief has no reasonable prospect of success. Can I take the court to volume 1 where the original notice of motion appears. At volume 1 at page 2. Page 2, paragraph 3.1a sets out the main relief that GOSA wanted to seek in the main application. It was an order that the period of validity of all licenses for firearms that were issued and will still be issued in terms of the Act will be extended to the lifetime of the owner. Now, Mr. Justice Prinsloo advised GOSA to abandon that relief, and they abandoned the relief. They accepted his advice. One then comes to the first main alternative, which is at the top of page 3. And there, GOSA wanted to seek an order that by order of court, the periods referred to in sections 27 and or 24.1 and 24.4 of the Firearms Control Act will be extended in order for people that hold expired licenses to apply for the renewal thereof. In other words, they were seeking an order of the court, a fiat of the court, that all periods referred to are extended beyond the provisions of the Act. Mr. Justice Prinsloo also advised GOSA that that was not proper relief, and he advised them to seek the relief which he formulated, which is now the first alternative, and that is relief that the order which he ultimately made, what's encapsulated in the order which he ultimately made, if I can just find it. It is paragraph 3 of the order which the court finally made. What the order is what the acting on the advice of the presiding judge, the GOSA amended the order which the main relief which would now seek to this, but by declaratory order of the court, the periods referred to in sections 27 and or 24.1 and 24.4 of the Firearms Control Act 60 of 2000 may be extended in terms of section 28.6 thereof in order for people that hold expired licenses to apply for the renewal thereof on good cause shown within a period determined by the court. In other words, the order to be sought has changed. Previously, it was an order. They were going to seek an order that all firearm licenses, dictated by the court, that all firearm licenses have the expiry period extended. Now it's an order that this is what the Act actually means, that the Act means that you can apply after the expiry period has passed. His Lordship said that these were just cosmetic changes. Well, cosmetics go further and further these days, as we know. It was a fundamental change in what GOSA is now seeking, and it was changed on the advice of His Lordship Mr. Justice Prinsloo. We say that it's a matter for comment. That of course GOSA can seek whatever relief it wishes, but we say that what happened is a matter for comment. In any event, So
are you saying the judge descended into the arena?
That's Justice Meyer, that's a polite way of saying it, yes. He descended, he took over a role which is really the role of the parties, which is to formulate the relief which they seek. As it turns out, we submit that the advice, that even with that surgery and that advice, there is no reasonable prospect that the new main relief will be granted. And that's dealt with in our heads of argument from paragraphs 58 to 62. If I can take the court there, it's simpler just to go straight to those heads. It's at page 25 of our heads of argument. We say in paragraph 58 that section 28, subsection 6 of the Act confers on the registrar to extend any period contemplated in this section on good cause shown. And then paragraph 59, we point out that section 28(1)(a) of section 28 cross-refers to the expiry periods in section 27. And so it's arguable that this power of extension also applies to the expiry periods. That's a matter which has been debated in various places, doesn't need to be decided in this case. We submitted paragraph 60, that what is not arguable, and we say that what GOSA has not contended, although I think they do now contend it, is that section 28(6) confers on the registrar the power to extend a period which has already elapsed. When a license has not been renewed within the specified period, it expires by operation of law. The section says it terminates. It ceases to exist. Monty Python would have something to say about that. Its validity cannot be extended when it no longer exists. It is, in the words of Monty Python, demised. And the authority for that is given in footnote 58, where we refer to the judgment of the Constitutional Court in ex parte administered social development. There, the court held that the power of the Constitutional Court to extend the suspension of invalidity of a statute exists only until such time as the period of suspension has expired. Once the period of suspension has expired, the court has no power to extend it because the court does not have, quote, the power to revive a law that has already become invalid, close quote. And a similar conclusion was reached by His Lordship Mr. Justice Plaskett in the Joubert, Galpin and Searle case in the Eastern Cape. There he held that once a tender validity period has expired, it cannot be extended. There's nothing to extend because the tender process has been concluded. Once the validity period has expired, there are no valid bids to accept. And we submit that in the present case, once a license has terminated by the effluxion of time, there is no longer a license which can be renewed. It's not possible to extend the period of the validity of that license. The remedy of the owner is to apply for a new license. And we submitted paragraph 61 that if Parliament had intended to give the registrar power to revive an expired license by retrospectively extending the prescribed period, it would have said so explicitly, most likely in section 27 itself. And if we give us an example of that, section 38 of the Arbitration Act, which provides in terms that the court may on good cause shown extend any period of time fixed by or under this act, whether such period has expired or not. That's what Parliament does when it wants to give a power to revive something which has already expired. And we say in paragraph 62 that it follows that if section 28(6) does authorize the registrar to generally extend by license validity periods, that can only be done prior to the expiry of the license, because a license that is expired cannot be renewed. And we refer to what was said by the court in the by the Pretoria High Court in the South African Hunters case, a judgment of which the respondent is very fond. And this is what the court said in that case. I'm of the view that one can't read subsection 6 to mean that if the license has expired, one can through an extension of time revive it. Such an interpretation will go too far and may circumvent the purpose of section 27, which is to only allow for licenses with a limited time span. We respectfully submit that that is correct. Now, the only answer to that in the judgment of His Lordship Mr. Justice Prinsloo and in our learned friends' submissions is to refer to Form 518A of the regulations under the Act. And they say that this means that Form 518A means that the Act does permit the renewal of an expired license. That is dealt with in our heads of argument at paragraphs 74 to 76, at page 31 of our heads of argument. Paragraph 74, we point out that on page 3 of Form SAPS 518A, which is attached to the regulations which are made under the Act, there is a box where the applicants can indicate whether they apply for renewal firstly 90 days before the expiry, if not, why not? Secondly, after the due date, before expiry, if yes, why? Thirdly, after the expiry of the license, and if yes, why? And His Lordship, Mr. Justice Prinsloo dealt at length and repeatedly with this box in the form. We've given the footnote in the footnote passages where he referred to it. And it's the basis on which he made his finding. He held that the existence of this box in the form, quote, suggests that there is full provision for renewal of a license already expired, close quote. And we submitted paragraph 76 that the law in this regard is trite. Regulations issued under a statute can't be used to interpret the statute. It's the other way around. The rule has one of its earlier origins in a judgment of, in the Moodley case in the then appellate division. There's also the judgment of Rousseau in the Supreme Court of Appeal. There's the judgment of Sabola in the Constitutional Court. It's trite. You can't turn the statutory scheme on its head and interpret an act by reference to a regulation which is subsequently made by a minister. And so we submit that His Lordship erred fundamentally in employing form SAPS 1518A to determine the meaning of the act and the renewal regime. And that's really the end of the argument that you can renew or extend after expiry, because no other explanation is offered as to how Parliament can be understood to have intended that result. That brings me to the fourth submission, which is that there was no admissible evidence which could justify the order. And we submit that the application is founded for the most part, firstly on hearsay, secondly on double hearsay. For example, in a press reporter reports that somebody else said. That's double hearsay. Thirdly, double hearsay. Seems like my clients seems to be upset about something, lady.
Carry on, please, Mr. President.
So there's hearsay, there's double hearsay. There's double hearsay in which the document which the deponent relies on isn't even produced. There's double hearsay in which there's just a reference to an online source with no explanation of what's in it. And it also rests on bald assertions, statements about what happens to what many policemen do and what many police officials do, and bald statements without any facts which justify those statements. And we
Sorry, Mr. Budlender, just on that point, may I ask you a question, because it's something that troubles me. I looked at the founding papers very carefully, and I saw that the right that GOSA relies upon is the right to just administrative action. That was the right that they relied upon. And this right, so it was alleged, arose from a legitimate expectation that the authorities would have disposed of a system regarding the administration of the Act. This legitimate expectation, as I read it, was created as a result of concessions by the police that they did not have the capacity to administer the system. Now, on first principles, I would have thought that there would be some facts, and you must help me here because I might have misread the record. Were there any facts to support these contentions? I mean, that's the case that's made out.
Justice Skippers, with respect, no, there are no facts to support that proposition. There are bald assertions, and I'll come to those in a moment. But there are no facts alleged. There's no evidence that X did Y at place Z. You don't find that anywhere. And
excuse me, Mr. Butlander, is Judge Zondi here? Mr. Butlander is Judge Zondi.
Yes, Judge.
Can you hear me?
I can hear you, Judge.
Oh, that's great. Just on that point, I just want to refer you to page 499 of the record, volume 4. It starts from line 20. And
yes,
then
Judge,
line 23, the judge stated, in my view, bearing in mind the urgency of the case and the general accepted circumstances illustrated in this press report, and bearing in mind that the respondent in the answering affidavit did not deny these allegations, I'm satisfied that on the weight of the evidence, it is clear that dishonest and untoward behavior in certain ranks of the police at certain location when it comes to the guarding and handling of the farms has become the order of the day. And he used his own experience to justify that conclusion. Was that correct?
No, Judge. Justice Zondi, it was not correct. There is not evidence which justifies such a finding. And the statement by the judge that this is a matter of public knowledge, of which he is, as an ordinary citizen, can take judicial notice, is with respect utterly without foundation. These are the judge's opinions, and he's entitled to those opinions. That doesn't make them facts in the case before him. I want to expand about. I will come back to that, Justice Zondi, in a moment. Firstly, I want to make the submission that a lot of the assertions of the kind to which he refers, to the extent that you find them anywhere in the papers, they are bald assertions. They are not justified by any facts. And we refer in our heads of argument in this regard to what this court said in the Syntheta case. A bald assertion does not establish facts necessary for a legal conclusion. You can't state factual conclusions or make bold assertions and say, I've acknowledged the facts. You must allege what happened, where it happened, when it happened, who did it. And so we say that the repeated bold assertions and then the judge's reliance on his what he said was his own knowledge and what everyone knows is without foundation at all. Of course, we do know that hearsay evidence can be admitted under certain circumstances. We know that it's dealt with under Section 3 of the Law of Evidence Amendment Act of 1988. And what Section 3 says the court, Section 3 says where the court may admit hearsay evidence. It says the court having regard to the nature of the proceedings, the nature of the evidence, the purpose for which the evidence is tendered, the probative value of the evidence, the reason why the evidence is not given by the person upon whose credibility the probative value of such evidence depends, any prejudice to a party which the admission of such evidence might entail, any other factor which should, in the opinion of the court, be taken into account. Where the court has had regard to all of those factors, then it may admit the evidence if it's in the opinion that it's in the interest of justice. Now, His Lordship, Mr. Justice Priestley, didn't, as far as we can see, consider any one of those factors, let alone consider all of them. He simply said, I admit it because it's urgent and everybody knows this. And we say that the hearsay evidence was all utterly inadmissible. In the GOSA affidavit, it didn't attempt to address the area in the Law of Evidence Amendment Act, and in our learned friends' heads of argument, they don't attempt to address any of the criteria in the Law of Evidence Amendment Act because they're not on the evidence. And the High Court simply ignored that. They didn't have regard to them, which is what Section 3(1)(c) requires. We say that the High Court gave three explanations to this problem, that the applicants didn't produce what was referred to as real evidence. The first reason it gave was that it said that it relied upon, quote, authentic newspaper reports, close quote. Now, the fact that something is an authentic newspaper report, of course, doesn't prove its truth. That's, of course, not evidence. It's pure hearsay, and usually a double hearsay. Secondly, the court said that the deponent for GOSA, Mr. Oxley, is an, quote, experienced deponent who has been involved in these matters for 30 years, close quote. It's not clear whether he was finding that Mr. Oxley is an expert witness. Mr. Oxley didn't attempt, as far as I could see, to qualify himself as an expert witness. But even an expert witness must give facts to justify his conclusions. You can't simply state conclusions and say they're true and you then rely on them because he claims to be an expert. Expert witnesses set out facts, they set out reasoning, and then they reach conclusions. Mr. Oxley sets out conclusions. opinions, assertions, and conclusions. And then thirdly, His Lordship, Mr. Justice Prinsloo, said that the appellants didn't deny the hearsay allegations. Now, we say two things in that regard. Firstly, it's not correct. The defendants said this is all hearsay and inadmissible and falls to be struck out, and there were multiple denials. They are quoted some of them are referred to in our heads of argument at footnote 78, some of the denials which were made. Can I add two more passages at footnote 78 where there are denials which were made? Firstly, you'll find another denial in volume 2, page 354, paragraph 99. And you'll find a further denial at volume 2, page 354, paragraph 101. And so there were denials. His Lordship was incorrect in that regard. But in any event, the position with regard to inadmissible evidence was clarified or stated clearly by the Constitutional Court in the SAFU case. The reference to the SAFU case, it's President of the Republic of South Africa and others versus South African Rugby Football Union and others. It's 2000, volume 1, the SA Law Reports, page 1, the judgment of the Constitutional Court. And at paragraph 106, there was an issue there about inadmissible evidence, and it was contended that it hadn't been answered, and somehow this was then rendered admissible. In paragraph 106, the court held as follows: if litigants elect not to deal in their answering affidavits with evidence they consider to be inadmissible against them, they run the risk that such evidence will stand unanswered if their objection fails. But if their objection succeeds, their failure to deal in an answering affidavit with inadmissible evidence cannot make such evidence admissible against them. So even if there were no denial, it wouldn't make the evidence any more admissible, because a failure to deny, there's no duty to deny that which is inadmissible.
May I please have that reference again, Mr. Butler?
It's, milady, it's Justice Meyer, it's President of the RSA versus SAFU, 2000, part 1, SA 1, and it's at paragraph 106.
106, thank you.
Finally, in this regard, we submit that one of the most striking aspects of these lengthy papers which were dumped on the respondents at short notice is that there is not one affidavit by a single firearm license holder who says, this is what has happened to me, and this is how I have been prejudiced, and this is why this relief needs to be granted. There is not one. And we deal with this in our heads of argument in paragraph 91. In paragraph 91, we say, paragraph 91, although the Act has been in operation since 2004, that's for 14 years before this application was launched, and despite GOSA's claim to great experience and a large membership, in the papers they claimed a membership of 4,000 people. Now the claim is somewhere near 6,000. But despite the claim to a large membership, GOSA was unable to produce a single witness who testified to the matters on which it relied in its hearsay evidence, and it provided no explanation for its failure to provide any witness. Now that challenge was raised in the answering affidavit. It was raised 3 times. Can I give the court the references? It's raised firstly in volume 2, page 339, paragraph 48. It's raised the second time in volume 2, page 355, paragraph 102. And it's raised a third time in volume 2, page 359, paragraph 359. Each time, the respondents or the appellants say, why is there no evidence? Why don't you put up a single witness to justify these allegations which you make? In its replying affidavit, GOSA did not respond at all to this challenge. It didn't say, well, the reason we didn't put up witnesses was the following. It simply failed to respond to the challenge at all. And we submit in sum that on the fourth point, there is simply no admissible evidence, even leaving aside separation of powers and leaving aside all the other questions on which could justify the order which the court made. It was an order made, as with respect, Justice Zondi has correctly pointed out, on the basis of the judge's own view of the matter. Finally, that brings me to my conclusion. We make the submission that for all of these reasons, the appeal should be upheld and that the order of the court below should be replaced with an order that the application is dismissed. I need to address deal briefly with the question of costs, which is dealt with in paragraph 99 and 100 of our heads of argument. It's the last page of our heads of argument. We submit firstly that the BioWatch principle does not apply to this case. And we find support, it's not raised in the for the occasion of BioWatch. It's actually practical because if one goes to the practice note, page 2, under the heading Constitutional Questions, the respondent says the respondent substantial constitutional issue. And on that ground, we say the BioWatch principle doesn't apply. We say, secondly, that in any event, the Constitutional Court excluded from the BioWatch protection a category of cases. And the category of cases is even where a genuine and substantive constitutional issue is raised, the rule doesn't apply. Where the litigation was conducted in a, quote, manifestly inappropriate, close quote, manner. We say, in this matter, GOSA brought an application which was entirely without merit and which was based on assertion and without admissible evidence. If one puts a line through those parts of the founding affidavit which are not evidence, which consist of either hearsay or bare assertion, one finds it's probably about 70% of the founding affidavit. False to be struck out. We say that the was manifestly pro-planner and being fanatic not only that lots of basic rule and for both of us, no cross-tracing manifestly pro-planner not much the response protect our water. Ask under what we are sweet council, we ask the of the who is and as one of those declared a stop and cluster twos.
develop your position on a credible man on the basis of the lead number as ordinarily fired. What would it be up and what's cost?
I think you've muted yourself, Mr. Butlander. Just
I'm sorry.
There you are.
Justice Skippers, the court would have had to dismiss the application for an interdict because the final relief which was going to without foundation means that the application should be dismissed.
Yes, thank you.
Any further questions, colleagues? All right, would this be a convenient time to take the tea adjournment or a comfort break for 15 minutes? any glitches, our IT official is right on hand to assist us. So I think we'll be all right. Anything you want to bring to my attention, you want to ask? Someone had asked for permission not to rope. Who was that? Who was it? Germany?
Judge is one of my juniors, Advocate Vani.
Oh, I see. Oh, all right. I did notice. Okay, no, that's fine. All right.